Good. Hello, everyone.
Hey,
Welcome to our Fellowship of Justice panel towards a more just world. My name is Damian. I'm the communications director at Kleros. Um, Fede, do you want to do the introductions for me, or do you want me to do it myself?
just say that well, we had a very interesting morning with different discussions about lots of things.
Indeed.
Crowd law,
We had
yeah,
pretty interesting discussions regarding different aspects of decentralized justice. And we're continuing our afternoon sessions with two very interesting panels, one of them being focused on the work that our fellows have been doing. I'll tell you a little bit more about the fellowship in a second. And the second one will be about Kleros law and the future of arbitration, which will also be a very interesting panel for all you lawyers out there and legal tech experts. When we're talking about our fellowship panel, our fellowship has been instituted in August 2018, if I remember correctly. The entire idea was to start exploring a little bit more in depth the use cases of Kleros through trying to network different experts from the fields of computer science, mathematics, economics, law, social science, and business. Since its inception, we've had the opportunity of welcoming 37 global experts in different fields from all corners of the earth, who have successfully completed their 6-month programs or are in the process of completing at this point. I have the distinct pleasure of welcoming 3 of our experts here today. 2 are from our first batch of fellows, and 1 is from our second batch. I will give you a little bit of a background of theirs. They're pretty fantastic people. The first one is Luis Bergola. He's a professor of practice at the University of Arizona and is a doctoral student at the Stanford Law School. For his dissertation, Luis uses a mix of qualitative and quantitative methods to assess the role and impact of party-appointed expert witnesses in adjudicatory settings like civil trials and international arbitrations. Outside the law school, he's a research assistant at the Hoover Institution. Luis was also in the U.S. Securities and Exchange Commission Honors Program and was a visiting researcher at the Georgetown University Law Center, both in Washington, D.C. in 2017. Abir Sharma is an Indian dispute resolution lawyer and a legal researcher with a multidisciplinary professional interest spanning across public policy, jurisprudence, energy law, and international arbitration. He's highly optimistic about the potential of new technologies to disrupt the contemporary regulatory framework and the theory and practice of law, and is an avid supporter of reformation to bring the existing legal regime up to date with the 21st century. The third one, and not the least, is Mauricio Duarte, who is an attorney and notary graduated with honors from Universidad Francisco Marroquín, which is a very interesting institution that we might touch upon later on in the conversation. Before obtaining his LLM in U.S. law at the University of St. Thomas, Minnesota, he worked at one of Guatemala's most prestigious law firms, where he specialized in energy infrastructure investment, corporate governance, international investment, and commercial arbitrations. He's currently working as a legal entrepreneur and chief operating officer at A2J Tech, which is a very interesting institution that I warmly suggest for you guys to check out. When we talk about the presentations that we'll be discussing today, we'll be discussing their work at Kleros, but we'll also be discussing a little bit more broadly the topics that they're researching these days. Abir, we'll talk about the Uniform Domain Name Dispute Resolution Policy that has been adopted by the Internet Corporation for Assigned Names and Numbers, or as we better know it as ICANN, to oversee any disputes that may arise between various stakeholders regarding the registration of Internet of domain names. And of course, connected to that, how Kleros can be utilized as a viable alternative to help enforce the Uniform Domain Name Dispute Resolution Policy. On the other hand, Luis will be speaking about the adoption of Kleros in a very complicated economic and political setting, such as that of Venezuela. He will be giving us an overview of this declining trust in the judiciary and the ever-increasing reliance of individuals and businesses on alternate methods of payment and currency conversions in the state, which is something that we are witnessing more and more across the globe in different states as the COVID crisis increases, and also due to political and social unrest. And this state of affairs always sort of opens the room for alternative scenarios, one of them being Kleros to become adopted in this hectic climate as a solution for the Venezuelan economy. He will also give us his take on the topic, as well as presenting some research questions that he's investigating as part of the case study on Kleros that are part of his ongoing study. Mauricio will be presenting on the topic of peer-to-peer energy markets and how Kleros represents one of the few mechanisms capable of solving disputes in this emerging industry. In order to put things a little bit into context, Mauricio, you will allow me to just put a little bit of context beforehand. Places like Brooklyn, Texas, Paris, and Japan, as well as other countries, find themselves investing heavily in renewable energy by prosumers, of which we'll speak a little bit more later on, which can then be sold without using centralized distributors, using smart meters and blockchain technology. This novel approach to local energy solutions is something that is a burning topic in many places in the world, and Mauricio will show us how Kleros can tie into this to even out the playing field even more. Now, these three topics might seem a bit divergent, but I'm sure that it will be a very interesting discussion that will find some very interesting connecting points, especially because the main one is, how do we use Kleros to better the world? So without further ado, I would ask Mauricio to tell us a little bit about his topic.
Okay, great. Thank you, David, and hi, everyone. For some, it's going to be late at night. For others, it's going to be early, or for someone, it's going to be in the afternoon like me or Fede. But I'm going to try to make it as short and sweet, and I'm going to also add some additional context to what Damien was just mentioning. So I'm going to share my screen right now, and I know I hate sometimes that I got to share my screen, but I think it's going to be pretty useful only to guide you through the motions of what was my thought process when I was approached with this specific project or investigation proposal for Kleros. So as David mentioned, I was in international arbitration, specifically in energy infrastructure. So to those who don't know what international arbitration is basically an alternate dispute mechanism. So instead of going to your local jurisdiction or your local courts, you agree beforehand by an arbitration agreement to submit your disputes to arbitrators and sometimes to a panel of experts. It depends. So with my experience and with my approach in the energy industry, one of my main concerns was that the energy industry was always centralized. And when you think about the potentials of blockchain in general as a decentralized technology that is going to allow peer-to-peer markets, not only in the financial industry, but in almost any industry, I started to think, okay, but there's probably, if blockchain technology is going to impact every industry, how is it going to impact the industry that I was at that moment, that was the energy industry? So I decided to take a look at this article that I'm showing right now on my screen that said blockchain meets energy. And it showed the different applications and the different potentials from blockchain for the energy industry. However, one specific quote jumped to me, and was this one. And I'm gonna read it only because it seems more powerful if you just read it than if I read it, I guess. So when I read this phrase, I was like, then there's something that we can do, and there's probably a research opportunity on how then we can advance the use and implementation of blockchain in the energy industry, but is related to other components. So what this author said, the question of whether a blockchain makes sense for an energy industry application is often not a technical one at all. Rather, a closer look at the specific application scenario with its economic, regulatory, and ultimately non-digital technological challenges is the necessary first step. So what are the real struggles of why blockchain hasn't made that leap in the energy industry? Are, at least from my perspective, are two main reasons. One, the policies and regulatory aspects, but with that comes the lack of a venue that is available to solve disputes in decentralized markets in which now people are producing their own energy and selling their own energy. So I'm going to explain a bit how this works. So I'm going to show a video right now, and I think my audio is sharing. So it's a 2-minute video, but it's gonna put in better context, in better words, and more visually why I decided to take on this project. So let me know, Damien, if the sound is on, but it should be working. It should be working.
Mhm.
Hurricane Maria took out power to all of Puerto Rico. Transportation, communication, and water for 3.4 million residents were wiped out overnight, not to be restored for months. But this scenario isn't unique to an island nation. Power grids all over the planet suffer the same vulnerability: centralization. One station down means millions lose power. But the answer to this problem may lie, in all places, in cryptocurrency.
Instead of being one behemoth homogeneous thing that can rise or fall depending on a catastrophe, it can be a whole bunch of little connected islands that can be independent or connected depending on circumstances and conditions.
That's Michael Guerra. What he's describing is the Brooklyn Microgrid Project, a small power grid made up of houses on President Street. It's using blockchain, the underlying technology of cryptocurrencies like Bitcoin, to decentralize and share electricity. The project began last year with software startup LO3 Energy. Residents like Michael, who own solar panels, produce and sell clean power to other houses on the street. Using blockchain software for the exchange means energy can be provided whenever and wherever it's needed.
The power has been kind of one of the low-hanging fruits in terms of blockchain application. And the Brooklyn project is just one of many around the world where you've got something that is homogeneous. A kilowatt hour is a kilowatt hour. And it can be essentially transacted very efficiently on this peer-to-peer network via blockchain technology.
Blockchain acts as an automated accounting system. It tracks how much energy is available, how much it costs, where it is, and where it needs to go.
And it really is no different than any of the other things that have gotten a lot of press from the shared economy. A lot of people have heard about Airbnb, making money renting a spare room, or driving for Uber or Lyft or one of the new rideshare programs. To be able to use those concepts for something as fundamental and important to day-to-day life as electricity is really exciting.
And the microgrid project isn't alone. Grid Plus is also using blockchain to help make energy greener and cheaper.
I love the idea of having these viable alternatives all over the place, and those can be totally decentralized and be sort of the routine way that people get their power.
Hurricane Maria took...
It's worth to say that I don't have to preach to the choir about the benefits of the decentralized markets, blockchain, and the potential applications besides the financial industry. But when we're thinking about this new emerging industry that is really getting a lot of investment, and when I say investment, it's billions of dollars as creating renewable energy, we're looking at 3 technologies that are coming into place. One is smart meters that use artificial intelligence in order to measure how much energy your house is producing. So for instance, if you have a solar panel, or if you have a mill in your farm, but you're generating that energy, that smart meter is gonna count the amount of energy that you have produced, and the surplus can be transacted and sold to another house, to another property, to another farm. But for that, you would need traceability of where was it generated, was it entered into the main grid, which is, let's say, the system, the general infrastructure of the system in the energy markets. But besides that, you would need a platform or technology that allows a peer-to-peer transaction. So that's why we have blockchain, smart meters with artificial intelligence, but all of that is going to create that traceability of the surplus of energy that you're willing to sell. So if you look on the left side, that is normally the process that it works on the energy industry, which if it looks like a chaos, it's because it is. And besides, the regulatory challenges from every country make it very difficult to have a uniform or standard way of approaching the energy market. However, there are some common aspects. The one relevant factor on the energy industry is that it's full of stakeholders, and those stakeholders are only using a centralized system. However, now as we look at the decentralized industry, and I'm going to share my screen, is creating a simple system in which you, in your house or your apartment, depending if you have the necessary tools, you can create energy, you can sell it, and you can use the grid. So it could be the main grid or the centralized grid, or it could be other infrastructure that right now it's being invested upon by certain countries, for instance, Japan, Texas, Brooklyn, different states and countries are investing in infrastructure to create a more decentralized system of energy producing, and as well to avoid the saturation or the fall of just what the main grid. It means that no one else has energy. So this is just a simple, let's say, screenshot of how it would look. Let's say I have my house and I have solar panels. I can create that energy that is gonna go straight into the smart meter that is gonna count how much energy do I have, and then I can sell it to the main grid, or I can sell it to someone else. It's gonna depend on my preferences, the price, and economic incentives that you might have. So again, this industry is starting to get a lot of attention, as the video mentioned, is one of the low-hanging fruits on the potentials of disruption. If you ask me, I do think that if you're and I don't want to get political in here, but if you are a believer on the effects of global warming, for instance, you might see that renewable energy and using blockchain is a good path forward in order to make a more sustainable world than the one that we have right now. So again, the investment, the startups, and the projects around decentralized energy markets is increasing every year in an exponential way. So without giving more of that context, because I think I can speak all day long about this, is that this was let's say, the nail in the coffin that led me to create my research on how Kleros could be used in this specific industry. And it's different research institutes and startups, especially in the EU, believe blockchain technology could enable 3D decentralization, decarbonization, and digitalization of the electricity sector while empowering prosumers. And that's the first time that I came across with this concept. And prosumers was a term back in 1980, in which Ellen Wright said that there was going to be a moment in human evolution, in the economic evolution of humanity, in which consumers would not only buy products or services, they would also create them. And they could be let's say, a player in the market as well. So instead of just buying, they would produce as well products and services. So what are we looking at right now? With the decentralized energy sector, you can be a consumer of energy, but at the same time, a producer of energy. Let's say I have a solar panel, I'm producing energy, but at the same time, I'm consuming it. So the concept of consumers is starting to get more traction now in this era of shared economies, as the video mentioned. So that led me, again, to start my research on the fellowship of how Kleros could be used specifically for this industry. And I'm gonna be sharing some of my main findings, and I'll probably be finishing up in 5 minutes. I extended a little bit more than I expected, but I hope you understand. And I just giving you the summary or the quick recap of the findings is that right now, at least how with the centralized system that we have, not only on the grid system, but on the dispute resolution systems around the world, on the main grid or using this centralized infrastructure, what we have, at least worldwide, is that less than 30% of people, and consumers in this case, have access to resolve disputes. So for instance, let's say one producer of energy is not giving the exact quantity that they offered, or the pricing is not being the price that it was agreed upon, or there are changes that sometimes don't have let's say, a regulatory backup, then the consumers don't have any recourse. They don't have anywhere to go. Cannot go to a jurisdiction, or they cannot even go to arbitration because it simply doesn't make sense with the cost related to an arbitration or going into the court, because again, energy and electricity is something that you need daily. It's a consumer aspect. It's a consumer related dispute. So right now we don't have enough adequate mechanisms to solve the disputes. And for instance, in England and in some other countries, you have alternative dispute resolutions, not focused on arbitration, but you have, for instance, mediations or ombudsmen that are people that try to bring the parties together and get into an agreement. But overall, there's no much recourse that consumers can have, at least in the energy industry. So what are we looking forward is how Kleros, again, Kleros as one of the few disruptive ODR platforms around the world that is capable of integrating with smart contracts, can solve disputes in a collaborative and decentralized market. Meaning that the philosophy behind Kleros makes sense with how the say the dynamics of the market, especially a decentralized peer-to-peer energy market, works. So that here we are, and we're looking to make a transition down the road, and it's going to take some more time, but that's where we want to be. So these are the main findings. If I could reduce my, let's say, research in 5 main pillars, these are the ones, and I'm just going to explain very quickly each one. So number one is, if we start using Kleros for this type of industry, is that consumers, again, this new concept that is going to gain more and more traction as we increase not only our technological capacity, but as new industries start coming up in this new digital economy, is that prosumers will have recourse for disputes against peer-to-peers or against any other player in the market without relying only on centralized mechanisms. Most of the states have, I would say, based on my research, 95% of the countries have a centralized mechanism of solving disputes, and just few countries have alternate dispute resolutions. But that's what we're looking at. The second thing is, as we look how Kleros works, and I don't have to probably explain the dynamics of Kleros because most of you probably are aware of how Kleros works, is that if you can create a specialized court in knowledge on electricity or peer-to-peer markets on decentralized energy, you will have jurors that would have the knowledge and the understanding to solve disputes in something that might seem complex, but once you study it, it's not complex. The only thing that you really need to know is how the dynamics of this industry work. So as long as you have the qualifications, you have the experience, you can serve as a juror, and obviously the whole dynamics that you might be selected randomly, but you have to put pinactions to be selected as a juror. The third finding, again, just recapping all of my fellowship research, is that the decentralized market and how it works, again, using smart contracts, using blockchain technology, using smart meters, is compatible with the infrastructure of Kleros. We have 2 industries or 2, let's say, industries that are working on blockchain already, that you don't need to create some complex integration in which, if we want to say it in a colloquial level, it's not something that is going into the internet and we gotta build a complex integration with something based on blockchain. It's something simple that at the end is just a matter of getting sharp minds of saying, okay, let's just communicate with this agreement. If we're gonna have a purchase and sell agreement of energy, we're just gonna have Kleros as the solving dispute mechanism. And the final 2 things, and before wrapping up, because I don't want to extend too much, is the automatic execution of the judgment or the decision from the jurors. It's gonna create more efficiencies and it's gonna draw more investment and incentives to this industry. Why sometimes you're hesitant to invest in, even if it's a country or in some industries, is because you don't have the clear picture of the possible contingencies, or let's say if there's even if you are an attorney and you're trying to select a venue for a dispute resolution, you're always thinking how the courts react. Is that a good venue? Does it make sense? So if we start incorporating Kleros in this type of industries, it's going to create an additional incentive to elevate the investment on these industries and therefore expanding the decentralization of the energy market, allowing for consumers that at the end of the day, you're winning because you're going to be earning money on the side by just creating surplus of renewable energy. And I think that's something that everyone can get behind. If you're just laying on your couch or in your bed and you're making money only because the sun is shining, I think that's a pretty good deal for everyone. And the final thing is that the excessive dependence on the current state-sponsored infrastructure in most states has led to the congestion and inadequate mechanisms to solve disputes. So we got to start thinking that there are other mechanisms that, again, as Kleros is one of them, they're probably going to be additional in the future. But if Kleros can start, again, focusing on this type of emerging industries, is going to be a good path forward. And it's not only going to have an impact on access to justice, but it's going to have a direct correlation with the investment and acceleration of this industry around the world. So again, if we want to make a rapid summary, I have the 4 key findings. Blockchain smart contracts and smart meters are going to change how the energy market works. The second one is that because of this new technological advancement, we're going to have peer-to-peer energy markets in which you can trade or sell to, let's say, your neighbor, or you could sell to the main grid or to someone else. The consumers now will be replaced with prosumers. For instance, myself, I am a consumer right now, but I do envision, and I would like to be in a short-term future, a prosumer, in which I can create renewable energy and sell the surplus of that energy. And the final recap is that right now, at least what we have right now, probably Kleros is one of the best ADR tools for this type of peer-to-peer markets. I focus my research on energy, but there are many more peer-to-peer markets, and probably some of my colleagues are going to speak about it, but that's probably what I have for today. I extended a little bit more, short and sweet, but if you have any questions or you would like to discuss additional projects or avenues of research, we're always happy to collaborate.
Thank you very much, Mauricio, for this wonderful presentation and beautifully designed presentation, if I may add. I think that there are a couple of points there that I very much enjoyed that sort of can sort of seep into this discussion a little bit more moving forward. One of them, of course, you know, the energy sector is one of the most neuralgic points on planet Earth at this point. Serbia is in a situation where renewable energy is too far away at this point to be instituted, exactly because of regulatory frameworks that are very rigid and very difficult to change. So I think this is one of the things that we will be able to discuss, especially with Lewis and his presentation, and Abir with his in these very different fields. But this is something that we will be facing moving forward. But let's come back to that towards the end in the Q&A session. So I would ask Abir if you can tell us a little bit about WIPO and what does Kleros have to do exactly with IP in ICANN. And hello.
Hey guys, what's up? Let me just share my screen right now. And as you can see, my slideshow is not nearly as attractive as Mauricio's. So you can all just focus on my pretty face. Now, the topic that I'm going to be talking about right now is domain name disputes. It's actually a very, it's a very common form of dispute resolution that takes place, but it doesn't really get covered that much in the news media or anything like that. Although there have been certain high profile cases involving all sorts of celebrities such as Madonna and Jethro Tull, ranging all the way to actual national governments. But first things first, what exactly is a domain name? This is not exactly rocket science because, I think everyone fairly well knows what a domain name is when you use the internet, right? It's the thing that you type into your browser address bar. As you can see, there are certain parts of a domain name. There's the protocol, which is the HTTPS, not important here. There's the subdomain, the www, which is also not important here. The part in the middle is the important part. That is known as the domain. That is basically, if you type in kleros.io, Kleros is going to be the domain, whereas the .io is going to be the top level domain. Now, all websites, they generally, the way the internet is mapped is that they have an IP address, which is a long string of numbers. But this is not exactly convenient to use for a regular user such as you and me. And therefore, the domain name system was developed in order to let regular people sort of navigate the web. It's sort of like the Ethereum name service that was recently developed. So you can actually send money to people's names, like through their names, to their wallets, instead of typing in the 13 alphanumeric code. But the moment that you have something like a domain name, which can be any regular name that you want to choose, that gives rise to a new challenge that basically, names have value. If you are a business like Nike, that name is worth, $500 million, maybe $1 billion alone. You do not want some regular guy, living in some shack in the middle of some podunk town, taking that name and making his own website where he's selling, 3D printed guns. That's not good for your brand value or, anything else. So similarly, you might have certain sentimental values attached to a name, which you don't want other people to misuse. So the internet, once it has this domain name system, it's not really ideal for it to turn into a wild west where people can hoard domain names. So for this reason, a governance institution was developed. It's known as the ICANN, Internet Corporation for Assigned Names and Numbers. Now, basically what the ICANN does is that it's a governance institution that ensures operational stability of the internet. It used to be under the aegis of a department of the United States until fairly recently, until other countries started objecting to the United States government having so much control over the global internet. So it evolved into a multi-stakeholder organization that basically administers databases related to the domain name system. So in other words, it manages the address book of the internet. As you can see in the picture over there, the way the ICANN is set up is fairly complicated, and it takes quite a little while to understand how exactly it's set up, because lots of different corporations, government agencies, civil society stakeholders have a say in how it's run. And then it basically has separate different registries, which sort of administer different top level domains. As you can see from the past slide, the top level domain is the thing at the end, right? The .com. But there are different kinds of top level domains, all with their own differing values, such as the .nyc top level domain has been given to a registry, which is under the control of the city of New York. And that TLD can only be used if you have a residential or business address in New York. Similarly, the top TV, .tv address is under the control of the government of Tuvalu, which is only going to allow you to register a .tv domain name if you pay them certain money. There are also certain specialized top-level domains that ICANN may sometimes sanction, such as .alibaba, which is operated and owned by the Alibaba Group. And there are certain controversies and struggles that go on with regards to top-level domains as well. That's a different can of worms. Like currently, there's this one top-level domain known as .islam, which has basically, been put into suspension because there's a whole lot of controversy over who is going to control that registry, with certain countries demanding that, it be like governed over some sort of organization that looks over the interests of the nearly 2 billion Muslims that exist in the world. So the ICANN has become this very complicated organization, which has a huge administrative headache before it. When it was initially set up, though, it was set up to solve this trademark dilemma, right? Because as we know, domain names are regular names, and they may sometimes infringe on a pre-existing trademark. So in order to solve this issue, the ICANN consulted with the World Intellectual Property Organization, which in a fairly detailed report recommended the creation of the UDRP, the Uniform Dispute Resolution Policy. Now the UDRP forms basically the fountainhead of the dispute resolution process regarding domain names, right? It helps resolve disputes that might arise in the smooth operation and the distribution of registration of domain names. Now there are 3 grounds of challenge. If, for instance, I register a domain name and one of you wants to challenge it, you're going to have to satisfy three grounds for a successful challenge. The first is that you have to prove that the domain name I have registered is identical or confusingly similar to a trademark or service mark in which you have a right. Secondly, you'll have to prove that I, as the registrant, have no legitimate interest or rights in respect of that domain name, right? It's not my dog's name or something like that, which I used in order to create a website devoted to my dog. Thirdly, you're going to have to prove that the domain name that I have registered is being used in bad faith. And you have to prove all three of these grounds. Now, what bad faith constitutes merits some further sort of inspection. Now, there are different, now this list which I've got here is not an exhaustive list, it's an indicative list, but so sort of explains the general categories of bad faith registrations that may take place. The first kind is cyber squatting, which is basically where a registrant buys a domain name in order to extort the actual trademark holder into paying a premium in order to buy that name back and create a website. Now, the seminal case that happened is from the English Court of Appeal. It's called British Telecommunications versus 1 in a Million. And this is from the late 90s. What happened here was a bunch of domain name pirates basically snapped up some very well-known brand names such as Marks and Spencer, Sainsbury's, and they demanded extortionate rates in order to give the domain name back to the actual right holders. And this sort of case forms one of the most important pieces of case law, which is still cited by tribunals and judges to this day. The second kind of bad faith registration that may happen is disruption, where the registrant takes a domain name in order to strategically deprive someone else, either for business purposes or for any other purposes of that domain name. And the best example of this is Taiwan.com. This was up for grabs in the late 90s as well. The government of Taiwan, I think they forgot to renew the domain name registration. Now, what happened was a mainland Chinese-controlled media agency known as Xinhua snapped up the Taiwan.com domain name and basically created a website in service of mainstream PRC propaganda rather than allowing the government of the Republic of China, Taiwan, to create its own website, which was pretty much a massive PR blow to the island of Taiwan. Thirdly, there's redirection, which is where the registrant snaps up your domain name, the complainant's domain name, in order to redirect traffic to his own website. And the best example for this happened in 2016 during the Republican Party primaries in the US presidential elections. So Jeb Bush was one of the candidates running for president back then, and the domain name under his name was up for grabs. Now, what happened was certain supporters of Donald Trump, he insists that he didn't do it or his campaign didn't do it. So let's take his word for it because we know he always tells the truth. But certain supporters of Donald Trump took laid claim to jebbush.com and basically redirected his website to the Donald Trump campaign website, which was back then considered a massive blow and one of the many reasons that Jeb Bush dropped out of the presidential race. These last two examples are sort of related with each other. There's one is typo squatting, where you'd buy a domain name that is a misspelling of an existing domain name or trademark, such as if there's google.com, I can buy up goggle.com. And similarly, combo squatting, where the registrant adds words to a trademark or domain name that may intuitively seem to belong in the name but really do not, such as there's nike.com. If I add nikeshoes.com, that's not the same thing, but some person who does not know any better might end up thinking that this is the Nike website. Now, this may be for perfectly innocuous reasons, right? I'll buy nikeshoes.com and just make a dummy site which is full of, penis enlargement ads, which, is going to give me a few pennies every time, someone clicks on it. on the other end of the spectrum, it might just be a straight up scam, right? And this happens a lot with banking websites where people do indulge in typo squatting or combo squatting in order to create a fake banking website and scam or phish the details of intended customers of that bank. So the UDRP exists in order to take care of such issues that might arise. And the ICANN has delegated a list of institutions to look over it. It keeps on periodically updating the list so that new institutions enter, some institutions fall out. Most of these centers are basically regular arbitral institutions, which help administer regular arbitration on the side and also dabble in internet disputes. What arbitral institutions do is basically they give you an infrastructure where they can recommend arbitrators for you. They can sort of give you the guidance of administrative staff, which is going to help you through the dispute resolution process. The main center that these disputes take place is the WIPO. They also have a certain dispute resolution center. And as you can see, the number of disputes that have been registered with WIPO have been steadily increasing over the years. Now, considering that all of these hallmarks, all of these institutions exist, we need to see what exactly they ideally try to cater towards. Now, the ICANN does not really set any sort of criteria that you absolutely have to cater to in order to be assigned by the ICANN as a dispute resolution provider. But each approved provider generally tries to aim to outperform national courts, right? So they end up harmonizing their structure and the way they administer disputes in that same way. And the criteria and the sort of aspirations that they try to work towards is low cost. They want to be cheaper than the regular court system. Secondly, they want to be faster than the regular court system. Thirdly, they want to be more convenient than the regular court system. And this will include email-only proceedings. You're not going to have any oral proceedings. You won't require any expert witnesses. You won't require any massive legal teams over the dispute. This is what they aspire towards. But while they might, in general, outperform national courts, it's not necessarily the case that they actually live up to these ideals that they claim to espouse. So let's look at some of the issues that arise in the existing framework of dispute resolution institutions, and let's see if it can be improved. The average duration of a WIPO domain name dispute, because WIPO is the main place where these disputes happen, is 2 months. WIPO filing fees start at $1,500 and they increase depending on the number of contested domain names and number of arbitrators. What this means is that if you have to challenge between 1 and 5 domain names, and if you want only 1 arbitrator, then you have to pay $1,500. Out of this $1,500, the arbitrator will get his fee and the WIPO will sort of take a bit of its own administrative charges. This does not include the cost of legal representation. There's no official data on total costs because many of these disputes are actually also private, but there is certain anecdotal data that suggests that it is high enough that registrants may be disincentivized from pursuing appeals. And the main anecdotal data I'm relying on here is my own personal experience. I actually did represent a party that was sued in the WIPO for having registered a domain name. So they lost their first round and they had an option of appealing it according to the rules of the registry that the domain name was registered under, but they decided not to because it was getting way too expensive for them. And it makes sense, right? $1,500 may not be a lot in, let's say, Switzerland, which is where I think the WIPO is based. But in a country like India, that is not exactly cheaper than court litigation, and people are not going to want to proceed when the costs look like that. Now, another problem here is that the pool of arbitrators that WIPO has and like all of these other institutions have is very limited. They have these very rigid and rigorous criteria for who actually can apply and qualify to be a potential arbitrator. You need certain years of experience arbitrating regular disputes. You also need certain years of experience being a lawyer representing parties in these sort of domain name disputes. And what that results in is a limited pool of arbitrators with a very, I'd say, biased worldview, right? They're very legalistic in their thinking. They're not regular, everyday people. And that might not exactly be the thing you're looking for when you're looking for options to settle disputes which are so intuitive and obvious, such as domain name disputes. Another problem with the existing sort of scenario is that there are no monetary damages or injunctive reliefs that can be awarded. The only sort of remedy either side has is that the WIPO or other arbitrator is going to give his decision, and within 10 days, ICANN is going to change whoever the registration belongs to, right? So if you successfully sue me in one of these institutions over a domain name I have registered, I have 10 days to challenge that in court. Otherwise, ICANN is going to take that registration and remove my name from it. And after that, one of you, whoever is the complainant, can register the domain name. On the other side of the spectrum, if I win, I will not get any sort of damages from you, even if you sort of ruin my reputation or whatever. All I will get is that you cannot take that registration from me. So the remedies that I have is sort of limited, and there's not much more in terms of enforceability going around there. But this is where Kleros steps in, right? First of all, if you ask me, the costs of dispute settlement are likely to be lower in Kleros, simply for the reason that the adjudicators or the arbitrators that Kleros will have are not likely going to be, legal professionals or people with that many specialized qualifications or experience. They can be regular people who are motivated to only preside over the dispute and be consistent with each other because their money is at stake. Now, I'm not going to go into the whole sort of Schelling point analysis, but I will point out that Kleros performs best when there are as little moving parts as possible in a dispute, or as we all call the proverbial low-hanging fruit of disputes. And I believe that this is where domain name disputes and Kleros together can shine, because there's not much sort of legal analysis that you need to undergo when you have to inspect whether a typo is there, which is in bad faith, whether you're trying to redirect from someone else's website to your own. That does not require much legal analysis. In certain exceptional cases, it might, but in, I'd say, 90% of cases, that is not necessary. So I believe that a Kleros jury is more likely to meet the objective, reasonable person standard that is required in such disputes. And the reasonable person standards, all it says is that if a regular guy on the street thinks that, the domain name is confusing, then yeah, it's confusing. Legal professionals who have gone through, 15 years of training and practice, they are not reasonable people. And I'll tell you that myself, I'm not exactly a reasonable person in these cases. I can give you all sort of but ifs and qualifications and hypotheticals on where I will not get confused by a URL or domain name, which some regular person on the street necessarily will not agree with. So I believe that, technical legal people are actually sort of detracting from the potential of domain name disputes under the status quo. Now, another important thing is, and a reason why we should sort of aim towards adoption of Kleros as a domain name dispute settlement platform is that, it's a nice testing ground for Kleros to prove itself as something that can scale up and take more, let's say, important disputes involving millions of dollars. It's a sort of stress test platform, because the mandatory administrative procedures prescribed by the UDRP, they're not finally binding, right? All they can do is change the registration. They cannot really sue you. They cannot put you in jail. They cannot demand any sort of damages from you, and it's not binding on the courts. You have that 10-day sort of a grace period where you can go to the court, and even after that 10-day grace period, you can still sue the person for defamation or unjustifiably, taking your customers, damaging your business or whatever you have. So if it's Kleros with such low stakes, it's a great place to actually prove that this platform is not a sham, basically, where all you can do is have disputes relating to cryptocurrencies and have all sorts of sorry for the harsh words, but you can say, like, currently people think that Kleros is just a platform for cryptocurrency circle jerk enthusiasts, where they sue each other based on whether a token has been appropriately named or not, or whether some smart contract is working properly or not. So,
but isn't domain names the same thing?
Domain names
in some other in some other way.
Well, domain names actually involve, real businesses and real, like, more brick and mortar businesses and real people, right? If I have a presidential campaign, I'm not going to be doing it on the blockchain. I'm going to be doing it out on the rallies and campaign trails. So I think that this really takes Kleros outside of the blockchain sort of culture and into regular people culture in a sort of staggered and safe manner.
Definitely.
And coming to the enforceability part, you know that...
if I may just point out time.
Sure. Yeah, all I'm going to say is that, Kleros smart contracts, they may allow you to award damages, take certain security for costs, which under the current framework is not really possible. So that's why I think that Kleros would actually be the ideal platform for domain name dispute resolution. And we should probably lobby some WIPO Pro and ICANN professionals for the same. So that's the end of my presentation, in case anyone has any questions.
Thank you very much, Abir. Knowing a little bit about ICANN and hanging out a little bit with the ICANN guys, I have to say that it's one of the more interestingly organized institutions, and it could be, in some sense, a match made in heaven to actually connect these two together. And I agree completely. But again, we'll come back to that after Lewis's presentation, because I'm dying to hear what is happening in Venezuela and how we can actually use Kleros in such a crisis climate. And also, one other thing before we begin, since it's 7:45 at this point, I wanted to ask Federico, would it be okay to extend our panel a little bit so we can cover 5 minutes of a Q&A, and then you guys can go ahead?
Yeah, that won't be a problem, I think.
Very good. All right. Lewis, I wouldn't want to take any more of your time, so you can begin.
Happy to start as soon as Abir stops sharing his
I have
screen.
no idea how to do that. I'll just stop my video. Did that work?
No, I think you have to stop sharing your screen.
There we go.
Okay, there we go. Sorry.
It's okay. That's a wonderful backdrop you have there.
Oh, yes, that's autumn at Stanford last year. Let's see. Are you seeing my screen? No, I'm still seeing Abir's.
Sorry, that's done.
Okay. Okay, I hope not to disappoint anyone if I start my presentation by telling you a little bit about a case study that I'm running with Karen Seif and John Ecken about Kleros and the social legal approach that we have taken in conducting in this research. And then we'll talk a little bit about Venezuela towards the end. I would like to say that since this is an ongoing case study, I think I see more advantage in being brief and letting leaving an opportunity for discussion later on, because I guess I'm as interested as you are in learning what you have to say about the way we are approaching these questions than I am about sharing what we have been finding so far. And I guess it's also important to say that many of the things that I'm going to say are things that are well known to the other fellow panelists here. But we present this case study as valuable for the community at large that is not necessarily familiar with Kleros and, well, the folks that we hope are in the audience today. The way we frame our case study is inscribed in the social legal tradition. We are very much interested in how interventions in the field of law play out in reality as opposed as to how they are expected to play out as written in the books. I'm not going to spend too much time on the literature that discusses claimant behavior, but we depart from, I don't want to say depart in the English sense of the word, I guess we start with the study of Macaulay from 1963 about non-contractual legal relationships. And to make the long story short, I just want to convey the idea that legal sociologists have been able to establish that non-breaching parties in a contractual relationship not always, and as a matter of fact, not as often as people would expect them to, resort to contract law to obtain redress from the damages that they suffered by the fact that their business partner, that the business partner didn't live up to the promise in a given contract. And then other scholars in the field have explored the issue of non-litigiousness from other perspectives. But the bottom line is that you have to look outside of the courts, the places where people adjudicate their claims in a society, to understand that the majority of potential claims that exist at a given point in time don't necessarily end up in court being resolved by a judge or an independent adjudicator, as would be the case of an arbitrator. The vast majority of claims tend to be lumped, as sociologists like to say, for different reasons: economic, sociological, even religious reasons. So my passage through the Kleros Fellowship got me thinking about how is Kleros, if implemented widely in a given society, is going to serve as an incentive for changing the attitudes that individuals in different societies have adopted towards claiming in the past, now that we live in this new decentralized blockchain society. So we ask basic questions, and our intention is to come up with the first independent big picture study on Kleros that is not issued by Kleros people, and that goes beyond the mere description of the platform that you observe in the few independent papers that have been published so far, that basically briefly describe Kleros, briefly compare Kleros to similar platforms, and one specific paper that shows some skepticism and criticism towards Kleros. So we ask basic questions. We want to know, what are those problems that Kleros solve in reality? And this is a question that we ask out of the belief that the traditional Bob and Alice scenario with which Kleros has been marketed was a great idea for the global society and for the little guy who is looking for avenues for alternative ways of obtaining cheaper services or cheaper goods by interacting in the global economy. And then we try to answer the question of what is it, if anything, that is holding Kleros from, taking off big time and becoming what it's meant to be, according to what we all know from the different Kleros materials that are out there. So I will not surprise anyone if I tell you that our preliminary findings from this case study are in line with things that have been mentioned by others in this panel and before in our different interactions. We see something that we like to call the decentralized sheriff. Kleros is serving as this important observer in the realm of token listings, and that's the majority of the cases that we see out there. So we keep wondering whether Kleros is going to be limited to this, or whether this emerging niche area, as we call it, is enough in itself to support Kleros as a viable enterprise, which is perfectly fine. And then we try to pinpoint the hurdles that are holding back broader adoption, and those might be apparent to all of you members of this panel who have actually used Kleros or might have experimented with the platform. And then finally, not least important, we take our inquiry, and I know for a fact that Sophie Nappert, for example, is one of the people who are in the field of arbitration that are very much concerned about the role of Kleros as a device that could help create the trust that is necessary for any dispute resolution system to be viable and to work effectively. So let me go back to the previous slide, actually the previous here. So we are employing mixed empirical methods to try to answer these questions and write the big picture description of Kleros. We are using content analysis. We're looking at the cases that exist right now, the caseload that Kleros has, and we have conducted interviews with the Kleros management, with Federico and Dr. George, and we have interviewed other people, other stakeholders, other users of Kleros, and more importantly, we have deployed a survey, and to reach out to a relevant group of people, we have used Kleros's own Telegram chat to distribute the interview, which means that we have to acknowledge the fact that we have, for sure, a biased sample. We are looking at people who are into Kleros already, and we are describing their own attitudes towards Kleros. And this is fine because we are trying to precisely measure attitudes of people who are interested in Kleros. A next step in the future for this case study that we are considering would be to run a survey to the public at large, as opposed to a group of people who are already knowledgeable and are using Kleros. But the main findings that we received from this preliminary survey, and we have a bunch of other findings, but I just want to concentrate on this, is the fact that the main driver that is taking people into Kleros is the desire to invest in Kleros's token, as opposed to use Kleros as a dispute resolution platform. I'm not trying to say that people are not into that aspect of Kleros, but the majority of the respondents, at least of our survey, indicate a desire on either investing on the token or making money as a juror, but fewer members of this community are into using Kleros for resolving the disputes that they might encounter in their own dealings. And another important thing that we are observing here is that of our respondents, there seems to be a trend in high knowledge about cryptocurrency. So we are not saying that this is the main hurdle to a broader adoption of Kleros in society, but the people who are constantly using it so far are folks who understand this field, who understand cryptocurrency, who understand blockchain, who understand smart contracts. So I guess the next steps in our study would be to ascertain whether this is what is holding back Kleros, if we can say that it's still being held back. We have been, as part of our study, we have been experimenting with the platform ourselves. So when I try to transfer or to create an escrow to secure a contract for the transfer of 1,000 pinakins to my co-author, Jan, I attempted to create a smart contract with the amount of pinakin in escrow. And the amount that was being charged as a gas fee was outstanding, was about 3 times the amount that we were trying, the amount of the contract price. So we all know that this fluctuates. We all know that the summer was not a nice time to conduct these kinds of transactions. And we know it has fluctuated down and it fluctuates up. And the main problem that we keep seeing in the responses from our survey respondents is about the uncertainty that this creates. And well, to the extent that users are not able to rely on, not on Kleros, but on the price of gas, is something that makes folks think twice about securing a transaction through the Kleros escrow, for example. What is important to us from our social legal perspective is that something that we expected to see, the graph on the left indicates that those who win, those who succeed in their cases are likely to do business with Kleros again. What is counterintuitive for us who have studied the social legal literature is the fact that there seems to be neutrality from the vast majority of respondents in our survey when the experience is negative. And this is interesting because if this holds true as Kleros develops, and perhaps it's something that we'll be able to find out if we run a survey at large and the finding holds, it's an indication that goes contrary to the findings that Macaulay and the other authors that I mentioned earlier established from the 60s onwards. So you will have an example of a society, if you want to call the group of people who deal and transact business and obtain goods and services on the virtual market. If you want to call that group of people a society, this would be the first indication of a society in which there is a trend that claiming and having a negative experience doesn't necessarily detract those users from keep using the system, from being repeat players when the experience is not positive. We have a bunch of case study conclusions here that are all preliminary. I don't want to spend much time here. I'll leave the slide here, but I do want to say a few things about what's going on in Venezuela. So why don't we go there? And then if time permits, we'll come back to the preliminary conclusions that I had. The problem in Venezuela is that we have a political situation that has created a serious impact both on the economy and the ability of the state to handle cases through the local tribunals. If you look at the graph, this is the amount of civil and commercial rulings issued by tribunals of first instance in Caracas during the period that goes from 2006 to this year. And what we see is that the blue line marks the average of rulings that are issued in first instance by those tribunals. These are typically the cases that involve contracts and dealings among merchants. Venezuela was a country in which there was almost 40,000 rulings of first instance every year. And we see a decline in the tribunal's ability to handle cases that starts, let's say, from 2014 onwards, to the point that in 2020, with the little help that we are all receiving from the pandemic, the tribunals are basically shut down, are not issuing rulings on these matters. So not only the fact that the citizenry is not relying on the Venezuelan courts to decide the disputes that arise from their commercial enterprises, the tribunals are actually not taking those cases. So that, in addition with the fact that you have rampant inflation and a de facto reliance on the US dollar for any transaction at any level in any part of the country, has contributed to shrinking the Venezuelan economy. So most businesses are not having access to lines of credit. Everybody is dealing on the day, and everything is being charged cash. So it's been really difficult for the median enterprise to keep functioning as they used to in the past. And well, we are not seeing the local arbitration centers in Venezuela stepping in to absorb the caseload that typically would have gone to the tribunals. This is data from the SETCA, the main arbitration center in Caracas. You see 2015, 2016 was probably the case that had the most cases, 20 cases of domestic arbitration in a country that, if you compare Venezuela to the neighbor Colombia, the Bogota center is running over 2,000 cases a year. So we are not ourselves trying to create a use case for Kleros. Rather, we are speaking with NGOs, students, people in the field of tech, at the intersection of tech and legal studies in Venezuela, to encourage the incorporation of Kleros in some way or another into a micro sector of the Venezuelan economy that could allow us to observe in a very specific way how Kleros could work in a society that lacks tribunals and that has no access to liquidity, because the local currency disappeared. There's no access to bills or coins, and dollars are not in as much circulation. There's not enough offer of U.S. currency to conduct the transactions that need to occur in an economy like the Venezuelan. So people keep wondering about why or how the Venezuelan economy keeps functioning to some extent, and whether something like Kleros could come in and fulfill the role the courts used to fulfill in a society. So there's a number of research questions to ask at this point. If Kleros were to be incorporated by any of these groups of stakeholders, I guess the opportunity to expand the scope of our case study would be unique. But at this point, we are basically waiting to see what happens. And I guess I welcome any questions that you have as to how we have been approaching these questions, these research questions, and the case of Venezuela, which is a very interesting opportunity to test Kleros.
Thank you very much. Thank you very much, Luis, for this wonderful presentation. Unfortunately, we have eaten into the Q&A time by a lot, and our speaker Mauricio has had to jump on to another call. So I would sort of wrap this discussion up as fast as possible with a sort of let's say a conclusionary remark on my side, which is that we've had the opportunity to see three different use cases in three very different fields, and a wonderful analysis of what Kleros is. And sort of what resonated in my mind the most is this idea of Kleros as a decentralized sheriff. I think don't hold me to this, but I think I read it in Howard Zinn's People's History of the United States, or I'm not certain completely, but there was this idea that sheriffs were instituted in the so-called Wild West at one point because there was a complete lack of judiciary. So it was necessary to somehow regulate a certain space, and I think that this resonates quite well in this small, as Abir said, in this small space of cryptocurrencies, of blockchain on Ethereum. It seems that Kleros can find some kind of space first and foremost within it, as we've seen in the earlier sessions, as well as finding some kind of another place in the real world, starting from the use case in ICANN and dispute resolution there, and as well in these spaces coming from a country that has also been functioning very deeply in this informal economy in the 90s. It seems that with these tremors, global tremors that are coming and that are already here in certain places in the world, Kleros can find its place there. And on the third side, looking at the renewable energy sector and something that is a look forward to a brighter future, perhaps Kleros will find its place even there. I think that in what sort of drove me a lot in this discussion was that we seem to be finding ourselves in some kind of a generational struggle. I connect one of the things that came to my mind as well is this idea that Salim Ismail was saying about exponential institutions, how technologies become faster and cheaper by every year, with every passing year. And I think that in some sense, Kleros, as it is right now, it is a small experiment in some kind of a novel field, but at the same time, moving forward and with all of the advances we are making these days, we are moving forward to something that I believe can be a very interesting place where we can all find our place online. I would like to thank all of you for participating in this panel, and I wouldn't like to take more time off of our fellow colleagues that need to start their own discussion in a minute. So thank you very much for this, and let us continue this discussion on Telegram.
Thank you for those amazing presentations, guys. It was amazing. Thank you, Luis. Mauricio, he's not here anymore, and Abir. Thanks a lot for coming. And I have lots of comments and questions to make to the panelists. What I find first is that it was really a good idea to do the fellowship, because look how much brain power we have for studying different use cases and trying to find solutions, find problems and then solutions to different disputes, some of them old, others new. Just one thing that you're going to be interested with, just yesterday we started our first test of using Kleros, like a non-crypto, if you want, use case. It's in a traditional rental dispute in Mexico between like a landlord and tenant, like landlord saying the tenant didn't pay the rent, and so there's Kleros that's going to make a decision whether rent was paid or not, and then so we're doing this with a mediation center in Mexico. So this is the first step to taking Kleros into the non-crypto world, and of course we know this is very important.
I'm familiar with the case. Actually, I was checking it because it was one of the first cases that differed from the bulk of cases that we have seen in our study, and it's interesting how creatively the lawyer has incorporated language in the contract to make it possible to nationalize, if you want, if you will, Kleros decision into the realm of a national legal system. So by the arbitrator adopting the Kleros decision and writing into an arbitration award, then indirectly you have Kleros jurors rendering a decision that is enforceable under Mexican law. And I found that was brilliant. I just can't wait until see how that evolves, because it provides a very nice example as to the kind of thinking that the lawyers and the scholars with whom I'm having a conversation in Venezuela can think about ways of implementing or incorporating Kleros into a society and a legal system that is in worse shape in that case than the Mexican.
That's great. And so this idea of how to put Kleros into the contract. So this is part of the research that Mauricio Virues, who's the Mexican lawyer who did this, the fellowship report he wrote, and he already submitted it, and it's on the review now, explains how under Mexican law that type of selection of arbitrations is valid, and yeah, I of course I will share this with you. Well, and you give me the perfect topic to go into the next panel, which is going to be moderated by